law update, today sponsored by our partners over at the Workforce Development Board of Ventura County. My name is Anna. I'm the digital media and event strategist here at the California Employers Association. And again, we just want to thank you for joining us live for today's training. Before we get into the content, I have just a couple details to go over with you, especially if this is your first time with us. So as you see, your audio is muted for today's presentation, but there are going to be lots of opportunities to engage during the training. If you do have questions about the content, you can put those into the Q&A or into the chat box at any time, and we will do our best to address them as we go. I'll be here the whole time supporting Astrid, so we'll make sure that we get those questions answered. If not, you always have the opportunity to call that HR hotline and make sure that we are able to spend some time on your question. Handouts will be dropped into the chat box shortly. So once you see that PDF icon and file name pop up, if you just click it, it'll download locally to your drive. Again, I'll be here the whole time making sure you guys are taken care of. So if you have any problems accessing that PDF, please just ping me in the chat and I'm more than happy to help you with that. As you see when you logged on, this webinar is being recorded and the team over at Ventura will be reaching out when that is available for review. So make sure you're active on that email list. And then last but not least, we will be inviting you to share your feedback at the end of today's training by participating in a brief survey. So it's only 5 questions. It takes about a minute to complete, but the feedback that you share with us in that minute, we share with our partners over at Ventura, and we just collectively make sure that we are meeting and hopefully exceeding your expectations with trainings like this. So at the end of today's training, you will see a slide with a QR code. I'll also drop a hyperlink into the chat, and we hope that you will take the minute to share your feedback with us. Again, our training is brought to you by our partners over at Ventura County, and I believe we have a partner joining us at the end today. So we will, we'll speak to some of their resources as we get started today, but we really do encourage you to reference your handouts that I'll be dropping into the chat for this hotline. Again, provided complimentary by our partners over at Ventura County. They also are able to connect you with just a suite of employer resources through their Workforce Development Board. So please take note of this information and we will drop some information into the chat shortly and hopefully hear from one of the representatives by the end of today. But now I'd love to introduce our trainer today. We have Astrid Servin, one of our amazing HR directors, and I'll be here the whole time supporting. So you are in great hands. I'll give it to Astrid.
Thank you, Anna, and good morning, everyone out in Ventura County, one of my favorite counties of the state. And just welcome today. And I know I think I do see some familiar names here that participated. So we may have spoken through this complimentary HR hotline, which is a wonderful resource brought to you by the Workforce Development Board there in your county. You're seeing the number there, so please jot it down and tell a fellow business owner about us, because they are also, so long as they're in Ventura County, can call into this hotline and we can assist you with a variety of issues and concerns that you may be facing as an employer. Anything from the whole entire employee cycle from beginning to end, from before you even hire that employee, some onboarding challenges, some recruiting challenges. We'll talk about what the laws are to be compliant and everything in between. So once you hire an employee, what kind of benefits do they deserve? If they need to go, excuse me, on a leave of absence, are they eligible for one? Meal periods, wage and hour issues, anything like that, give us a call if you're second guessing yourself and we'll talk it through. We even have sample employee handbooks that are not complimentary through the hotline, but you have that available resource if you wanted it through our website at employers.org. We also have a lot of other free resources at employers.org. So as an employer, I invite you to go over to our website and look at it. But through the hotline, you can give us a call 8 to 5 Monday through Friday. So a little bit more again about CEA. If you happen to have visited our website, you can see that we are a consulting HR company. So we handle HR hotlines for many of the counties in the state. And then we also offer training such as this one. So your county provides training throughout the year. So make sure you stay in contact with them. They select various topics and they're always good ones. We're going to talk about mid-year labor law update today, and we also have other ones coming up throughout the year. But a little bit more, if you need additional support, if you feel like you actually need more HR support than what the hotline gives you, you may want to consider joining as a member of CEA. Through membership, you also get more. You get things like project hours that you can use towards things like an I-9 audit, towards a handbook, With membership, you also receive templates that are there already for you to use, fact sheets, guidelines, some toolkits that you might need, and then additional training that we offer through our CEA University, and then also through this platform in Zoom, through webinars or even on site. So lots of things that we can offer you if you need additional HR support. What we are not is a law firm, so we can't offer legal advice either on the phone lines or in the trainings. And what we talk about is educational in nature. So you may get to a point where we say you need to speak to an attorney, and it's nice to have us so that we can kind of, in a less expensive way, package it up for you so that you can then go to your attorney and ask those questions, and then that conversation will be privileged and confidential, which sometimes you need. And we have great attorney partners that will talk to you and usually are at a pretty good rate as well if you ever need that. So let's get into our mid-year labor law update. This year we've titled it Navigating a New Administration. The reason being is that we're living in a unique time with a new administration that has changed a lot of things. So there's some federal developments that have been increasing in January and then kind of take turbo speed in June. So we're going to talk about all those, and then how does that impact California, especially in California with the most recent immigration enforcement. How does that impact? What do you need to be aware of as an employer? So we're going to cover those executive orders and those employer impacts, as well as California wage and hour updates, because California always keeps us on our toes when it comes to wage and hour. So we'll talk about some of those things. And then new case law and regulations, which we haven't had in a while. So we're going to discuss some new case law that might be important for you to note. And then we'll end and close it out with our summer reminders for California employers, and most of those come in the area of safety through Cal OSHA. So we'll discuss those as well. So let's get started here. Those federal developments that I talked about earlier, they've topped the news relating to mostly immigration enforcement. So we're going to begin by talking about the Form I-9 and the updates we've had to that form, but also what employers should be looking out for. Because we've heard that there's been a stated goal of 12 to 15,000 I-9 audits that will happen by ICE this year alone, which is a huge increase from what we've seen in the past. And we're also hearing that certain industries are going to be targeted or have been targeted, such as agriculture, hospitality, healthcare, and then sanctuary cities. So if you have employees in areas like Los Angeles, those are usually under more high scrutiny than other areas. So if that's you, we're going to talk about those I-9, how to prepare for those I-9 audits. And then also unique California requirements, because in California, there is some unique ways to go about that if you are to receive an I-9 notice of inspection. And then we'll end with those executive orders and DEI implications, some programs, because DEI has been somewhat confusing in the state of California. We're going to try and review those things as well with you. So let's start with the Form I-9. Let's refresh everyone about what's the point of an I-9 anyway. It's a federal law that we must follow to employer and new hires by verifying both their identity and their employment eligibility for all new hires that you have at your workplace. This has been a rule that's been in place since 1986. So unless you have employees who have been hired before then, you actually have to have a completed I-9 form for all of your employees, including any owners, CEOs, all of them, which tend to be the ones that don't have an I-9 a lot of times when we do these audits. They also need to have one, so long as they're an employee of your company. You don't have to do those for independent contractors because they are not considered an employee. Generally, the process is that the individual gets to pick how they'll show you their identity, and then the employer then looks and sees whether or not that falls into the requirements of the Form I-9. So you'll have to inspect that and make sure that those documents they provided appear genuine. And your training, you should be trained on this process of how to inspect, but you're not really tasked to see whether or not they are 100% true, but you do need to make sure that you're looking at them in a reasonable way to ensure that they seem legitimate, okay? And that's really your responsibility. There are penalties for failure to comply. They range from very simple $300 for minimum penalties for very small things, infractions, to more egregious or willful violations can be up to $28,000. So we want to make sure that we're doing things right, that we have an I-9 for all employees, and that you're checking your supervisors to whoever is verifying this, that we're doing it in the right format, in the right way. So let's do a little pop quiz. If you can locate your chat box, or you can either send it to the whole group or just to me, the host. Our new employees started work on Monday. When is the deadline to complete the Form I-9? So employee starts on Monday. Do you have to do it on Monday, on or before their first day of hire? Or B, Thursday, within 3 business days of hire date? Or C, within 7 calendar days of hire? Let me know what you think, you believe, when the I-9 form should be completed. Thank you for your participation, everyone, and I think everyone got it correct. It should be done by B, within 3 business days of hire. The only exception to that will be if you're hiring someone for project work or for something that they're going to be with you less than 3 days. Then you have to complete it before that 3 days, before their last day is up, before the completion of their term date with you. So, of course you can do it before then. And if you're going to do it before the date of hire, we don't recommend that, because we do need to pay employees. Wage and hour in California are very strict. So due to those wage and hour laws, we do recommend that you have them complete. You can give them the Form I-9 prior to the first day, but if they're going to complete it, it should be paid time. So make sure that we account for that, or that's part of our plan there for them. But yeah, so Thursday. So remember that Section 1 needs to be completed by the employee on that first day. But Section 2, that the deadline, that's when the employer has to do their part in verifying the I-9 with the correct documentation. Okay, so we have a new Form I-9 this year. It reduces the sections 1 and 2 to a single-sided sheet. I'm hoping you're probably using that already. It's designed to be fillable form, so you can use it on tablets and mobile devices, which is really nice. And it moves the section 1, the preparer translator, to a separate standalone where we don't need to include it anymore if it's not, doesn't apply, which most of the time it doesn't apply, so we don't need to print that out. And then it also moves section 3 to their own standalone supplement B. Again, we're only using that when we rehire or when we re-verify, so most of the time we're not using that, and so they've actually added it to a supplement. This form version has an edition date of 1/20/25 with an expiration date of May 31st, 2027, which means we can begin using this Form I-9. So should I correct or replace I-9s of current employees because there is a new form? This is one that we get asked a lot into our hotline, and the answer is no. As long as the version that you used when the employee was hired was not expired when the I-9 was completed, then you're okay. You should not update I-9 forms or re-verify based on the new form. And I'm pretty sure you know that because we've had new forms throughout the years. If you have an employee who's been there for a very long time, so long as that was the current form that was in place, then that's okay. And sometimes we do these audits and we find that maybe we had the wrong form, and that's okay. When you're doing the audit in good faith, you're going to write and attach a memo to it stating that you were unaware that the wrong form was used and that you're aware of this now and you've corrected that issue, that concern. So we'll talk a little bit more about auditing your I-9 forms here. It is recommended, highly recommended, especially right now, because it gives you an opportunity to correct these concerns before you get a visit from ICE, and it shows good faith. So because we've seen an increase in these audits, I know CEA has definitely seen employers be audited in the past. So we want to make sure that you're prepared. You want to discard any I-9 you are no longer required to retain, especially because there may be errors on that. And we don't want them to see those and possibly give you errors on I-9s that you don't even need to have in your files anymore. So go through and ensure that you have no longer retain those that you don't have to have, and then correct errors. Generally, you're going to, if you find an error, there's a concern there, you're going to draw a line through the incorrect information, enter the correct information. For example, you messed up on the hire date and the hire date was entered incorrectly. You're going to draw a line, enter the correct hire date, and then you're going to initial and date the correction. And the date needs to be in the format that's on the I-9, the 2-month day, 2-month month, and the 4-month, 4-letter, whatever, 4-number year. Never backdate an I-9. So if we've made an error, and it's easy to simply correct it that way, you're going to do that on there. But we're not going to backdate, and we're not going to use whiteout. So again, if you discover whiteout was used, you're going to put a memo on that. Whiteout was used. We understand now that we've been trained on the proper way of doing I-9s, excuse me, and we have corrected that. That's the way you would correct that I-9. So that those written explanations, those memos I'm talking about are very important. Sign, date, and attach it to the I-9. Never discard or shred an I-9. If there was an incorrect I-9 and you needed to redo an I-9, redo the I-9, but attach the old one to that new I-9. Again, this is all in good faith where you may have inherited old ones or a process that wasn't done 20 years ago and they weren't doing it correctly. Nobody knew how to do it. In I-9 audits I've done, we've discovered everything. And so you just simply, that good faith audit goes a long way. You're going to do a cover memo saying that an audit was done on a certain date and that corrections were made, memos were attached. And now moving forward, there shouldn't be any penalties associated, shouldn't, because we still see them sometimes, but that good faith goes a long way. ICE, the Department of Homeland Security, has said these audits should be done and they will be taken into consideration if there's an audit. So make sure that we're checking on that. If you need assistance on those I-9s, CEA does do those. I know we've increased the amount of I-9 inspections we've done, and we can do those virtually. We have someone sending us 600 I-9s to audit, actually, and we can do them virtually. They're going to send them through a secured file, and so that we can audit those, or we can go on site and do those as well. Or you can do them on your own as well. So feel empowered. Sometimes it's overwhelming, so it's nice to have somebody else do it, but no reason you can't do it yourself. So there is a California notice of inspection requirement. So if ICE or another enforcement agency comes knocking on your door, remember California has a unique requirement. So prepare to provide I-9 forms and requested records within 72 hours. Now it's recommended that you keep the I-9s in a binder. That's always been what many attorneys and law firms recommend. And we're going to keep one for all current employees and any terminated employees that are still you're required to retain. So an I-9 has to be retained for the minimum of 3 years, even if an employee didn't work for you that long. It's always going to be that there's a calculation that you use from either the termination date, the date of hire, or the termination date. And if that termination date isn't quite 3 years, you still need to retain that I-9. So then you have to post notice. So have them all very organized in a good, secure place. Then you're going to post notice of inspection for employees within 72 hours. That's California's requirement. You do need to notify employees of that. And when you do that, we need to give them, again, that heads up that they're going to be inspecting. It does need to be in the language that we normally communicate with employees. So if you normally have a handbook in a different language or notices that you give out, text messages, whatever policies, you're going to want to put that notice in that language as well if you're translating all policies. And then physically provide government findings to identified employees within 72 hours. That is also another requirement. So if you do find there's a discrepancy, there's an issue, then maybe ICE has identified there's a deficiency with your I-9 record, you do need to notify, the government needs to notify, you need to notify the identified employee within 72 hours. If you run into a situation where your employee can't be located for some reason, they stopped coming to work, they didn't report to work, you can satisfy your obligation as an employer by emailing that communication or mailing it to them as well. So notice of inspection is different than what we've been hearing on the news as an ICE raid. An ICE raid is typically referring to ICE not sending a nice notice in the mail that you're going to be inspected, but rather showing up to your business uninvited to speak to your employees or even to arrest someone. So, some tips around that. You may refuse to allow ICE to enter any non-public areas of your workplace unless they have a valid warrant. All your workers also have a right to remain silent. So that means, again, public areas such as parking lots or when customers or patrons may come in, those are all public areas. ICE can access those areas. And if you're concerned by that, you can be very clear about marking the private areas of your workforce if you need to, and so that it's identified as a public versus a private space easily to anyone. Other things employers are doing or considering doing are conducting ICE drills. You may want to consult with your legal counsel about how to train your workers if something happens. If you're working in an area where employees are panicked by that or concerned by that, maybe not showing up to work because of that, there's steps to take. You can prepare your workforce for that, of where they need to remain, and also letting them know that legal. They have I-9s on file. And so what do they need to do? How are they authorized to talk or not? And also they have, again, that right to remain silent. You can train their employees on that. Also, saying things like don't run. If you see an ICE agent, you don't need to run. You need to comply with what we're doing here. So those are just kind of some tips on workforce things that have worked for some employers out there. So to kind of end this area here of the I-9s, make sure that you're doing an I-9 audit regularly, annually, at least right now. This would be a good time to do it. That you're following a compliant process, that you're ensuring that you have one I-9 for every employee that you hire. And then be prepared to follow California's unique requirements should that happen. If you happen to be a CEA member, we do have a whole toolkit that goes through how to do an audit on your own as well. So another issue getting attention is DEI. Sounds like a dirty word now, the DEI, diversity, equity, and inclusion. So some little background or history lesson. DEI, diversity, equity, inclusion, developed or started gaining attention first in the 80s and 90s. It grew globally as competition grew globally, and it's gone through kind of ups and downs. And really the focus back then in the 80s and 90s was diversity, was increasing awareness and diversity, and it made really great strides. Things ebbed and flowed, and things changed in the workforces, and especially for groups of people to really advance. And then it kind of, again, with DEI, we've seen that ebb and flow, and companies really started focusing on DEI plans and programs. It grew attention in 2020 with George Floyd. It kind of took a spike then. We saw an 123% increase after that, and companies really just started embracing more efforts and had diversity, equity, inclusion groups in their workforces, statements, things like that. But then recently in 2025, there was a cultural shift with large companies pulling back from DEI programs and initiatives. Some customers started boycotting, large companies had setbacks. Companies like Target, Walmart, Amazon, what happened here? Arguably, the executive orders has had a direct impact on this cultural shift. So beginning of January, the new administration issued executive orders that focused on breaking down some DEI efforts, and again, arguably shifted things. So we're going to discuss those next, those executive orders. Let's talk about that because they did get a lot of attention and people are still kind of confused by them and the impact of their own company's DEI efforts. So this executive order 14173, titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity, takes the position that certain DEI programs create discriminatory preferences that violate federal and civil laws, or civil rights laws, and then revokes federal contractor and subcontractor affirmative action requirements, other than those veterans and individuals with disabilities. So this executive order issued in January, shortly after the president took office, it really it's showing that these preferences to minority groups that violate the civil rights laws in Title VII or the ADA, that was the focus of those. And then for the contractors, in the past, federal contractors that have 50 or more employees and at least 50,000 in federal contracts had to have a written affirmative action, that might have been you, a written affirmative action program, and audit those to make sure they were providing opportunities for underrepresented groups. So that's been changed and pulled back. No longer have to do that if you're a federal contractor. And then the third thing that came with this executive order is that it required the Attorney General to provide recommendations for combating illegal DEI and identifying potential high-profile civil compliance investigations. So again, this is the Attorney General was asked to select 10 large companies, corporations for enforcement who are engaging in illegal DE&I. So this is likely why you've seen corporations like Target, Amazon pull back, because they don't want to be one of those 10 companies that have done that. So because of all this, the EEOC, which is the Equal Opportunity Commission, which is federal, offered its own guidance on DEI-related discrimination, because how does that impact our workplace? So there is a bit.ly here that you can follow. It has some information on the EEOCs now, and we're going to talk about that soon too, the impact that this executive order has had on workplaces. So does this executive order, this is a big question, make DEI illegal? And the answer is no. It's a misconception that only minority employees are protected under the law. All employees are protected from discrimination and harassment based on those categories in federal: race, sex, religion. It doesn't say which one, it's all of us. All of us are protected, whether they're part of a minority or a majority group. So, executive order does not change discrimination laws. Employment decisions that are based on protected characteristics, whether they're part of a DEI program or not, have always been illegal. So as a practical matter, though, employers with DEI programs may come under increased scrutiny and enforcement, particularly large companies. I don't think smaller companies need to worry about that, but nonetheless, you want to make sure you're checking your DEI programs to ensure there's not any discrimination going on within them. So these are some best practices, reminders. DEI programs are fine, not unlawful to keep them. In fact, some companies are actually embracing them more than ever. But if you do, again, maintain a DEI program, ensure that it's not unlawful, that you are doing things such as ensure the employment decisions that you're making when you're hiring, you're promoting, you're assigning, do not give preferential treatment based on any race, sex, or any other protected class, that you're not doing things like quotas based on race or sex, and that there's no points for applicants of certain protected classes of minority groups unless mandated by law. So points meaning mandated by law are very limited. For example, certain government employers are required to give veteran applicants certain more preferential treatment. Also, your DEI program should not have, they should be voluntary for any person to join. It should be open to all. And then just kind of, again, practical matter or a good tip is maintain job descriptions and draft criteria in advance for all hiring and promotion. So meaning that you want to make sure that we're looking at things, are employees actually eligible for that position, not based on who they are, but what they bring to the table, what experience they have. Okay, the other executive order gaining a lot of attention that we'll review is 14168, which is quite a mouthful to say: defending women from gender ideology extremism and restoring biological truth to the federal government. This states that federal government will recognize only two sexes, male and female. It defines sex as the mutable biological classification and rejects gender identity concept. So this rejects the interpretation of the Supreme Court, which is federal ruling, including sexual orientation and gender identity in Title VII's protection as requiring gender identity-based access to sex spaces. So even though, again, the U.S. Supreme Court has included sexual orientation and gender identity within Title VII protections, the executive order states that that case shouldn't be interpreted to require gender identity-based access to single-sex spaces such as bathrooms. So it's not directly addressing it, the Supreme Court case, but the EO, the executive order, just doesn't want to take that court case, which is the Bostock case, and be twisted to make that requirement happen. So again, how does this relate to California? Is this in conflict with California law? As we all know, in California, this is not the law of the land. So the answer is maybe, I don't know, possibly. Because under California's Fair Employment Housing Act, gender identity and expression are protected classes. We actually have them as a protected class. So right now, it's recommended for employers to follow a more restrictive protection of the employee. So while federal regulations wouldn't require you to use a pronoun, a chosen name on a federal form, such as the I-9, you would be required to use it on things like your name tags at work, your employee ID cards, any kind of schedule, or the other, you could, if you don't do that, you could fall under a possible claim against you, or someone can sue you for harassment under FEHA, under the Fair Employment Housing Act in California. So in California, we want to make sure we follow a more restrictive protection, again, for the employees. FEHA regulations also require employees to have access to a restroom or locker room that corresponds to the gender identity and be addressed by the name and pronoun of their gender identity and expression. So, we'll have to see if the law goes how they kind of argue with each other. You don't want a harassment lawsuit, however, under the Civil Rights Department, and that is the law of the land in California and can very much happen. The Civil Rights Department has the authority to file suit against an employer for not following their laws in California. So we'll continue, keep an eye on it, kind of see a wait and see approach on this regarding how the EEOC will enforce the executive order that has been issued. And for any kind of liability concerns, we want you to consult with your legal counsel on it, since it's kind of a touchy situation where they're contradicting each other. So to wrap up, again, review hiring and internal policies to ensure no preferential treatment for certain groups. Draft objective job-related criteria for openings and train hiring managers and recruiters to make sure that they're looking at these objective job-related criteria. Maintain current job descriptions for all positions. Some of those job descriptions are very outdated. I've seen them. They don't really pertain to the position you have anymore. So make sure that we're not excluding groups of people by having an outdated job description. Continue monitoring federal developments and pending litigation. Subscribe to our blog if you're not subscribed already at employers.org. We're keeping track of these federal updates and executive orders and how they are being interpreted in California as well. So we'll keep you up to date with what's going on. All right. Yay, we get to get out of the federal law world and back into California, which sometimes isn't always any better, but with updates, we have a few good things in California to report, so that's good. We're gonna talk about wage and hour next. We have some July 1st local minimum wage increases that you should be aware, some industry-specific wage increases in the fast food and healthcare, and then new 2025 meal break waiver case that doesn't really change things for you, but it really solidifies we're doing the good thing. What we thought we were doing right happens to be right. So we have a case law that proves it now. We'll talk about that. And then California's recommended wage and hour audit because of PAGA. If you were in January, we talked a lot about the PAGA reform. We'll kind of recap and talk about that as well. So you all are aware that in 2025, the minimum wage did increase for our hourly folks to $16.50, which means the exempt salary is also at $68,640. And remember, that goes up as state minimum wage, not the local one, but as state minimum wage, you're going to have that exempt salary continue to move up. So be prepared. Come January 1 of next year, that will increase again. So we want you to be aware that if you need to transition an exempt employee to an hourly position, there's some few reminders and some tips, some employee relations issues that might come into play. So we have a little link here for you if you need to be aware of that so that you're looking out for that kind of stuff. I'm just going to check the chat real quick, make sure there's nothing there. Okay, good. All right. So locally, though, sometimes that does change. In July 1st, we saw quite a few increases to the minimum wage in local jurisdictions. So some cities, some municipalities, some counties where that did increase. And sometimes, I don't think sick pay was impacted much, but sick pay does usually go hand in hand with the county and city that has a higher increase. So always pay attention to that. Rather than put in all the July 1st increases on here, we provided you with the link that takes you to all the July 1st increases that have happened. So if you have employees working other than in Ventura County, because I don't think we saw any increases in Ventura County, but if you have them in LA or San Francisco or San Diego, especially in the Bay Area, there's quite a few cities that increased. So we want to be aware, where are they physically working? That's what the local minimum wage we should be following. And then also the sick leave that corresponds to that. Okay, if you're in the healthcare industry, you're going to want to go to this website here. As of October 16th of last year, the requirement was to change. There has been a change to the healthcare minimum wage. The range wanted to increase from 18 to 23 an hour, and there was an increase that became effective July 1st, where it increased again for certain healthcare, for most healthcare facilities, depending on how many employees you have in that facility. Not for all healthcare, but you want to watch out for these new supplemental minimum wage poster. Also, that's a requirement by the Department of Industrial Relations. And then also to any exempt employee you have in the healthcare industry, they follow a different exemption as well. It's not twice the minimum wage, or it might be, but it's also looking at 1.5 times the healthcare minimum wage, whichever one is greater. So you're going to want to look at that and pay attention to that. And again, if you're unsure, you're not sure if you're covered healthcare, we recommend you take a look at the Labor Commissioner's Office FAQs to see if this is you or not. We want to make sure that you are very much aware that this falls under who you are, and if so, you need to follow this new law. So make sure you're prepared with that poster as well if that relates to you. and or even call into the hotline and we can kind of review that with you as well. So we got a court decision on meal breaks. So we don't get a lot of court cases, again, like I mentioned before, on wage and hour, especially meal breaks anymore. So if we get one, we pay attention. And as a refresher, anyone working over 5 hours up to 10 are entitled to one 30-minute unpaid meal break. You can have a waiver if you are only working 6 hours total in that workday. And that's a mutual waiver. We've been doing this, we've been recommending this. I'm hoping you have that as part of your practice at your workforce, where you're having a waiver on file for all your hourly employees. If an employee works over 10 hours, you're giving them two 30-minute unpaid meal breaks. And again, the employee can say, I want to waive that second meal break so long as they're not working over 12 hours in a day and they didn't waive their first meal break. And we've had a nice, beautiful waiver. You may have been following CEA's waiver on that, or maybe you have your own that has that mutual agreement that either party can break that agreement if they desire to have a meal break that day. That's fine, so long as it has that disclaimer. So that's the way we've always recommended it. That's the way we've always had it. And now there's a court case that affirms that this is okay. That one waiver, sometimes we get that question, is do we have to have one waiver every single day? Or is it enough to have one on file? And now this court case definitively says that one waiver at the start of employment is sufficient for the life of that employee. So we present all new hires that may work shifts of 6 hours or less with a voluntary meal break waiver to sign at the time of onboarding for future work shift. Is this okay? And again, we're okay in doing this. This practice is okay. We've confirmed that with this court case that is okay to do. And I guess this is kind of the update here. And again, best practice is to have that clearly written and that waiver, and that supervisors are trained to ensure they're not coercing or pressuring employees not to take their lunch. This is the case that you're seeing here, that Bradbury versus Vicar operating. So this California appeals court confirmed that one waiver is lawful. Employees may make that advanced written waiver of meal breaks for anybody working 6 hours or less. They do need to be, again, in writing, knowing, involuntary, revocable at any time. You can't retaliate if an employee decides to take a lunch that day. They're working 6 hours and they're really tired, or they need to go somewhere and they need to leave, that you're allowing that. Best practice is to make sure the terms of the waiver and rights to revoke are clearly written and explained to the employee before they sign it. And we say train those supervisors and never pressure them because we've seen it happen. We've seen it happen with employers who maybe have this practice in place. Everybody signs that waiver, everybody works 6 hours, and we're all okay doing that. Then you have a new hire who says, I actually want a break. I know I'm only working 6 hours, but I really like to take that 30 minutes to eat my lunch or go run an errand, and I'm back in 30 minutes. And so I actually want that. But this practice seems to everybody seems to be in agreement, and I feel pressured to go along with it. That's where employers have gotten into some hot water. So make sure that's not your practice, that's not you, and that we are talking to our supervisors and managers to ensure that it is revocable at any time and that there's no retaliation. Let's talk a little bit about PAGA. So PAGA reform is again, a good thing for California, a positive thing for employees. PAGA is the Private Attorney General Act. And in California, that law allows employees to file a lawsuit on behalf of themselves or other employees for any kind of labor code violation, wage and hour specifically, and essentially stepping into the role of the state's labor enforcement agency and kind of suing you on their own. And under PAGA, employees can seek civil penalties for workplace violations, with a portion being awarded to the state. So it's kind of a win for the state too. And so, of course, when PAGA happened, which has been quite a while now, many lawsuits that cost employers millions sometimes of dollars, hundreds of thousands, tens of thousands, and sometimes even millions. So this reform is great because this reform imposes very strict eligibility and timing requirements and really helps reduce the penalties, because the penalties were so high. So if any of you had a PAGA lawsuit, you know what I'm talking about. They were huge, huge to defend. You had to spend thousands of dollars on attorney's fees to try to defend your claim, which you probably were wrong about, and the penalties were significant. So this new opportunities for employers to reduce their penalties is to demonstrate that you took reasonable steps to comply with wage and hour laws. Very similar to that I-9 audit. What they're saying is with this new PAGA reform, if a company shows good faith and takes reasonable steps, then they can have these penalties significantly reduced. And there's also a new opportunity to cure following a PAGA notice, which we didn't have that before. If you get a PAGA notice now, you're going to want to take action right away. But even before you get that notice, you should be doing these things, taking these reasonable steps. So you should be doing a periodic payroll audit and take action in response to results. So you may find that, oops, we didn't pay meal premium penalties when we were in the wrong. Or maybe we missed some breaks that weren't given to employees because we didn't have the adequate staffing. Maybe we missed that overtime, or we missed paying holiday pay, or we didn't pay out floating holiday when the employee left the company. Things like that were found. We're actually taking some sort of response to them. We're doing something in good faith to correct that. You're going to want written policies. So your handbook comes into play here. Your handbook's going to state all the wage and hour laws, that employees can take a break, and you have a little table of how many hours they work, how many breaks do they get. Employees should be taking their meal period by the 5th hour. That's in writing. Things like that. Those wage and hour overtime. When does overtime come into play? When does double time come into play? That you're setting those rules in your handbook so that you're making employees aware of it. And that you're taking corrective action for supervisors who are not following your policies. So if a supervisor fails to tell you that an employee worked an extra day, or they were entitled to holiday pay or a floating holiday, they didn't do their job when they're in notifying you, that you're taking corrective action against them. We have training available in a whole entire wage and hour package that's available to purchase at employers.org. It actually comes with a PowerPoint little short training. I think it's like 20 minutes long, for your supervisors as well. And this is a great way to show that you took reasonable steps. Not only did you do your audit, but you also trained your supervisors on these wage and hour laws so that they're aware. Okay, so some wage and hour to-dos here. Ensure your minimum wage rates are adjusted as needed. Review those local ordinances and industry-specific wage. Again, we didn't cover fast food, because I don't know that there's a lot of fast food industries here, but know that that's also one. The healthcare is another that has an increase in the minimum wage and the salary for exempt employees. So adjust those salaries for them as needed. Review meal period waiver practices and implement, very important, those reasonable steps in light of that PAGA reform, so that if you are caught with a PAGA claim, you've done your part, you're ready, and those claims, believe me, we've already started seeing them this year already, where these PAGA penalties are significantly, sometimes 75% less than what they used to be. So very important. Again, refer to our, if you're a member, you have that wage and hour package available to you. If you're not a member, you can still have that available in a wage and hour audit by visiting our store and purchasing it. Okay, let's move on from paying our employees to their rights and protections. There's some developments here in the Civil Rights Department with AI, with artificial intelligence. We have some reasonable accommodation case law update, which is again another win for employers, so that's great. And then some labor law poster and employee notice updates that you should be aware of, that some just came into play in July. So we want to make sure that we're getting them right. So the Civil Rights Department and the AI regulation, artificial intelligence. So Civil Rights Department is having issue, has had issue for some time now with these automated decision-making systems, these tracking systems that you use for your applications, for when you run a background check, when you do any kind of background check for an employee, that they're not being done correctly if you're using AI. So on March 21st, the Civil Rights Department approved regulations addressing potential discrimination when these tools are used to make personnel decisions. So again, mostly with screening applicants, screening any kind of background check. This was supposed to take effect July, right now, but now it's been pushed to October 1st. So good time to just make sure you're reviewing these things, that you're aware of them. I don't know that it's going to impact most employers that much, but just be aware, because I think it's going to be an unintentional thing that might happen. So these automated decision-making systems include any kind of artificial intelligence, machine learning, statistics, or other data processing systems. You're using those, you're just putting in the social and you're running it through a background check, that kind of thing. So with this CRD AI regulation that takes effect in October, they're just stating that the Fair Employment Housing Act, that's where all our workplace classifications live, that applies to AI. So we cannot discriminate, or AI cannot discriminate against race, religion, any kind of protected category that we have under FIHA. These AI tools may result in adverse impact discrimination. So again, they've gained massive popularity for employers to use. We want recruiters to continue to use them, but we want you to proceed with caution based on these things. So AI alone is insufficient for criminal history, individual assessment. And so because when you do a background check and you have a criminal background check, you've already made a job offer to the employee, you're running a background check, and it comes through, the Civil Rights Department has very important and very specific rules you need to follow for managing that individual assessment. And sometimes we leave it to AI or our carrier to do, whoever we're using, but it needs to be a human touch. It has to have a human touch to it. So again, great tools to have, but let's make sure that we can prove that a human has seen it, that we've actually looked at that background check, and we've done an individualized assessment based on our own understanding of what is on that report. And so you're, actually physically writing it or typing it and signing it off. Record retention of AI-related records also has a 4-year from the date of creation or personnel action involved, whichever comes later. So that's another thing. You do need to retain these things for 4 years. And they're really going to start cracking up on that. Remember that individualized assessment, I'm just looking here of what else I want to mention. That's for employers with 5 or more employees that have to do that individualized assessment and factor all that in and notifying the employee of any conviction that if you're rescinding an offer or anything like that, that needs to be done. Okay, so all this has been adopted before. We would say it may happen in July 1st, but this actually has happened as of October 1st. Okay. And I'm looking at the Q&A, and it looks like we did have a question. What if the employee shift, going back to our meal break, is 8 hours or 10 hours? So remember, we do need to have 1 meal break for that 8 hours. If they're working 10 hours, they do need to have that second meal break. But if they do have a meal waiver on file, then they can waive that meal break. I think that was your question. Okay, moving on, another court case we wanted to mention that's new for 2025 that just came through, provides some important reminders and best practices for employees managing leave of absence. We get this question daily, if not hourly, regarding reasonable accommodation. So this is actually a win for employers. It's Manos versus J. Paul Getty Trust. And the facts are here. The employee exhausted all family and medical leave. So they were on a leave of absence, and they requested further unpaid leave. I'm sure that sounds familiar to you, plus multiple extensions, which probably sounds very familiar to you too. So it kept going as only possible accommodation of continued disability, meaning they weren't ready to come back and they couldn't come back. And so they were asking, they had already exhausted any kind of FMLA, CFRA, anything like that, but they were requesting an accommodation under the Fair Employment Housing Act, so ADA, right? As an accommodation, I'd like to continue my leave. And so the employer granted it. And then they continued it a couple more times and the employer granted it. And they did that for a year. And then finally, they received a notice that said that the request was indefinite, meaning no expected end date for the leave. And then the employer said, that's not reasonable. And so we are terminating your employment. After, again, the employee said, well, it's indefinite, but I want you to continue accommodating. The employer said no, terminated their employment. That became a lawsuit, and it was founded that the employer was correct in the way they did that. So the decision was the court ruled in the favor of the employer. They highlighted that the employer's good faith efforts in what we call the interactive process is really how it was granted in their favor, because they did allow for repeated requests for unpaid leave. They reached out to the employee to explore other accommodations. So what this employer did was reach out to the employee and say, we know you continue to ask for leave of absence, but can you come back in any capacity, maybe for a different job? Here's the job site of our company where we have open positions. Could you do those? And it really showed, again, good faith. So we don't want to just to say a blanket, everyone do this, but rather look at what this employer did. They reached out continuously to the employee, offered other accommodation requests, and they probably knew this employee wasn't going to do it, but it really looked very good in writing. So Manos did, they completed the questionnaire. He didn't reply to any of the requests. So when they said, can you do these jobs? He never even replied. When they said, you know, is there a shorter time frame? He didn't reply. So all that was on the table was indefinite leave. And so what was the employer supposed to do with that? They kind of took a gamble and said, we're going to terminate the employee. So key employer takeaways, no obligation to grant indefinite leave. Now, if they say, I'm going to be back in a month, that's going to change things. But if it's an indefinite leave with no expected end date, then again, that is probably in this case was okay. No bright line rule for duration of unpaid leave as an accommodation. I know we get that question a lot. Like, we've already did it for a year. Can we terminate now? And we're going to say, talk to your counsel, because there's always going to be a risk involved with that. You may be ready to terminate at that year, but there's just understand there's going to be potential risk. And what you did in that year is going to be critical. You're going to look back and see how many times did you contact the employee? Did you offer any other positions? Again, even if it was just on paper, like, here are the positions open, can you do these? So you need to engage with that employee to determine, again, other potential accommodations. And again, we're going to advise you to consult with counsel before ending. But we do get this question quite a bit because it is very frustrating to have an employee that's just out there. What I remind employers is it's not really costing you anything to have this employee out, but it can cost you a lot to terminate them. So patience is huge here. You're going to probably end up seeing this employee out. We just need to be smart about how we do it and how we put it in writing. That's very important. It's called the interactive process. And the Fair Employment Housing Act actually has a form out there. You can Google it. You can go to our website, employers.org. They have an interactive process, reasonable accommodation form that will guide you on what to do. It's not, you're not obligated to use it, but we always recommend it. So labor law posters and notices, here are some anticipated updates and some that have updated. So the EEOC has a new poster marked Know Your Rights. It's undergoing revision due to the executive order that's been issued. So some language is going to change, but that hasn't been rolled out yet. California minimum wage posters has that if you're in the healthcare or fast food, or you are in a municipality that has increased, you may need to update your poster. And then the California Civil Rights Department did issue in July a crime victims notice. And that crime victims notice, we mentioned it in January during our labor law update. We're mentioning it again because that actually is out now. You can find that at our website at employers.org. You need to distribute that crime victims notice to all new hires and annually to all employees. So you do need to send that out to them now. And then anytime upon request, or anytime an employee informs you that they need to use that, or their family member is a victim of crime. Okay. So let's review this section. Ensure there's a human review of all artificial intelligence process for FEHA compliance and record retention. Implement AI policy for your staff, and then train your management on leave of absence and reasonable accommodation rights, that we're not just terminating them as soon as their FMLA or CFRA expires. Remember, there's also the reasonable accommodation process under ADA, under FEHA. Watch for updated posters in the Civil Rights Department crime victims notice. That crime victims notice is out and needs to be distributed to your staff. And if you are a CA member, again, you have access to a sample AI policy that you can use for your workforce. All right, we have about 6 minutes left here, 5 minutes so, that will remind you about some just to do, your calendar to do for this summer. We'll talk about Cal OSHA's heat illness prevention, our workplace violence prevention plan, and Cal Savers. So indoor heat illness, on July 23rd of last year, so just about a year ago, California adopted an indoor. We've always had an outdoor heat illness, but now we have an indoor heat illness that went into effect. It's going to apply to all indoor work areas when the temperature reaches or exceeds 82 degrees while the employees are present. It was mostly because most facilities, if they have air conditioning, will never be you. Your air conditioner usually is set so that it goes under 82 degrees, but it's aimed at manufacturing, warehouses, maybe some restaurant kitchens, places without full AC that might be, but it's not limited to those industries. Everyone has to have an indoor heat illness. You're just not going to have to do much with it because your air quality is controlled. However, you still need to have a plan in place. You still need to have that be aware of that. Remember, the outdoor places always had it. The plan is available. You can go to our website, or you can go to Cal OSHA's website and download that template. Cal OSHA has provided that template for employers. You just need to go through and finish it up and correct it. Our CEA members have a fact sheet that kind of goes through your requirements, what you need to do. I think there is actually a requirement here. So the essential requirements of this plan is that you have to have water available, cool down areas, an emergency response procedure, acclimatization if it does get too hot. You also have to have that, again, that plan, that written plan that we have a template for from Cal OSHA. You have to train your employees and your supervisors on that. And if you work in an area or environment that it gets really hot, so over 87 degrees, then you have additional requirements. So make sure that we're following this, that we're downloading if you haven't already, because this was implemented last year. We're just reminding you because you do need to train your employees on this and make sure that you have all that in effect. So what are our ongoing requirements for workplace violence prevention? Remember, that was something that came out last July. And if you acted quickly, you're coming up on those retraining plans now. So remember, we have to request feedback or solicit feedback from your employees now. Again, we have to do that annually so we can take their feedback into consideration and update our plan. So remember, you had to have a workplace violence prevention plan in writing. Annually, you need to solicit that feedback, and annually you need to train your employees. You also need to do periodic hazard inspections, periodic safety meetings, and those, as you were doing them throughout the year, need to be implemented and be placed as part of your plan annually. CEA has a comprehensive whole entire package that includes training through our CEA University. It also includes a PowerPoint slideshow that is available for sale. And our CEA members have access to the package, but you can always purchase the PowerPoint slide deck from our store as well. It just has everything that you need to train your employees on already done for you in a slide deck. All you need to do is personalize it. So you need to put in what your employees said, for example, in their feedback. So personalize that, and then it's ready to go. But update anything that might have come up in your hazard inspections or your safety meetings. If you had an incident that occurred, maybe two employees fought and there was a threat done, all those things need to be logged, and you need to make sure you're reviewing it. The last thing I'll mention is the Cal Savers retirement, and this is going to include everyone now. If you have one or more employee, the registration deadline is December 31st. So Cal Savers is a retirement program for employers in California who do not offer a retirement plan. If you do offer a retirement plan, you're okay, but if you do not, the deadline has been kind of increasing depending on your employer size. Well, every employer, if you have one or more employee, has to participate in this if they do not have a retirement plan. So make sure that you're registered through Cal Savers. Cal Savers pretty much does everything. All you need to do is register and then again maintain that roster, employee roster, and submit contributions if your employee signs up. There's no fee for the employer to do this. Participation is voluntary for the employee, but the obligation for the employer is to register. So you have a little to do here. Make sure you're complying with the annual requirement to train and speak to your staff on the workplace violence prevention plan, your development that heat illness prevention plan as needed, and registering with Cal Savers. We have some great safety partners here that we've highlighted if you do need help with that workplace violence prevention plan. So what's next for California employers? Ensure you stay up to date on your trainings, your mandatory harassment prevention training. We want to remind you about that. And then that PAGA, that's wage and hour training, make sure you're doing that to your employees. Keep your employee handbook current. If you need help with that, let us know. Comply with new wage requirements and pay attention to local ordinances. Make sure you have your labor law posters updated, that you're doing that crime victims law one, and then stay tuned to ongoing developments. You're in California, we never know, or actually federally too, you never know what's going to happen tomorrow. So stay tuned with CEA blogs. You're little past mid-year, congratulations, and if no one's told you, you're doing a great job. We're facing challenges in protecting our workforce from compliance to safeguarding their mental health. So you're doing a great job. Good job staying on top of it. Partner with us, continue to partner with us at Ventura County so that we can work together on any kind of concerns or issues that might come up. That, and just as a reminder, here's our hotline to do that. I'm going to throw it back to you, Anna, because I know we're on time. Thanks so much, everybody.
Woo. You are amazing. I do want to remind everyone that this slide is also in your PDF handout, so please take note of that. that page in your handout that I placed into the chat a couple times. Take a screenshot of what's on the screen right now if you need that handy dandy on your desktop. We just really want to make sure that you have that resource available. I also will be dropping the HRCI and SHRM codes if you are joining us. I'll drop those in a minute, but the slide that's on your screen now, we do just want to invite you to check out more information about becoming a full-on CEA member if that is something that you think would benefit you and your organization with a little added support beyond that HR hotline. Just a bunch of different options to choose from, all ways that we can help serve you in your business. I did just drop the link into the chat for that very brief survey. This is one of the questions on there is what type of trainings that you'd like to see in the future. So this is really a way for you to make your voice heard on what you'd like to see, whether it's more compliance, essential skills, anything and everything. So there is definitely a option there. And then those HRCI and SHRM codes, if you are joining us for continuing education credits today, HRCI code is 710943. SHRM code today, 25-UYX97. Again, those are in the chat for you. You need to copy those down. And also, if you don't know what to do with that information, but you are interested in getting certified or recertified, again, please reach out to us, ceainfo@employers.org, or call that complimentary HR hotline, and we're more than happy to guide you in the right direction to make sure that you get credit for joining us live today. I think that's it, my friends. So thank you all for joining us live today. Thank you, Astrid, for your time and expertise. Thank you, Melody, for everything that you do behind the scenes to make sure that our employers are taking care of in Ventura County, and the amazing team at the Workforce Development Board of Ventura, Cynthia and your team. Thank you all. And thank you all for joining us live. And we look forward to seeing you on the next training. Talk to you soon. Cheers.